Today's presentation will cover Aaron McNamara versus Barrera Recycling. We will talk about the case summary, the relevant portions of the collective bargaining agreement. We will discuss just cause, the sources of the provisions, defining just cause, and additional precedents. We will discuss how those apply directly to the case of Aaron McNamara, discuss biblical worldview, and a brief conclusion. Aaron McNamara versus Barrera Recycling involves a grievance filed for wrongful termination under the union's collective bargaining agreement. The assigned position in this case is the position of the labor relations manager, who is presenting a case for this termination to be considered just cause. In January, this employee was transferred, and by October, she was suspended with warning of intent to sever, with further violations occurring in the next 12 months. The suspension resulted from 7 different separated documentation of conversations with supervisors, including sleeping, safety violations, and neglect of duty. December 9th, she was terminated after yet another safety violation. The relevant collective bargaining agreement provisions include causes for immediate discharge, such as disobedience, neglect of duty, refusal to comply with plant rules, sleeping, and reading while on duty. There's a just cause provision also in the collective bargaining agreement. The sources of just cause provisions include government sources such as the state of Montana, which is the only state with a just cause as opposed to at-will employment. There are several municipalities throughout the country that have implemented just cause regulations, such as New York City, Puerto Rico, Philadelphia, and the U.S. Virgin Islands. Also, the International Labor Organization has implemented just cause language, and 35 countries have ratified this convention, including Brazil, France, Morocco, and Sweden. High-level executives and business leaders routinely negotiate contracts with dismissal protections, and then, of course, collective bargaining agreements. Most unions negotiate contracts, including just cause protections, and that is our primary issue that is going on here. The defining of just cause, the ILO defines it as employee of a worker shall not be terminated unless there is valid reason for such termination. Most just cause provisions list multiple things that could cause a just cause termination. For example, Virgin Islands has multiple listed, such as creating competition with employer, poor conduct, drug and alcohol use and subordination, negligence, excessive absence, incompetence or inefficiency, dishonesty, persistent conflict with coworkers. But Bud Pruitt quotes the arbitrator Carol Doherty's 1966 list of 7 tests of just cause. These tests include whether the worker was given advance warning, was the rule related to the safe operation of the business, was the alleged violation thoroughly investigated, was the investigation fair, did the investigation reveal proof of guilt, was the employer's discipline non-discriminatory, and was the discipline reasonably related to the worker's record and the severity of the conduct. When we apply this directly to the test case, we do find that the case study indicates that the written suspension provided contains specific warnings of the consequences of further violation of the company's rules. The requirement of wearing gloves was a safety requirement designed to ensure workers were not injured in sorting hazardous materials. So we do find that the warning was given and that it does relate directly to the safe operation of the business. There was no detail on the investigation, but we do know that the employee was spoken to on seven different occasions, so there's sufficient documentation of that. There's nothing to suggest that the investigation was nothing but fair and objective, and no complaint by the employee to that effect. The employee committed 7 documented incidents occurring over the course of the year, including disobedience, neglect of duty, refusal to comply with plant rules, sleeping, and reading while on duty, which are all causes for immediate dismissal under the collective bargaining agreement. The employer's discipline was non-discriminatory. There is nothing to indicate anything to the contrary. The discipline was reasonably related to the worker's record because It followed the exact consequence set forth in the prior uncontested suspension. There's additional precedent to discuss. One case in the Massachusetts Lawyers Weekly talks about two cases, the first one being the case of a just cause termination of a police officer that was off duty for illegal activity. Now, this isn't the same situation, but this could have reflected poorly on the police department, and her conduct would have cost reputation of the employer, as well as triggering possible safety audits. It was also determined in a second case that there was language repeatedly said that the plaintiff had not put forth the burden of evidence from which a fact finder could conclude, suggesting that there's at least a fair amount of burden of proof of evidence on the part of the employee that is terminated to prove that the termination was not for just cause, especially if there had been documentation of infractions. The English Standard Version of the Bible states in Colossians 3:23-24, "Whatever you do, work heartily as to the Lord and not for man, knowing that in the Lord you will receive the inheritance as your reward. You are serving Christ." As Christians, we're expected to do our work with excellence, and the behavior that the employee exhibited does not honor God. As a labor relations manager, the conclusion is that this termination deemed as meeting the standard for just cause. Further, it's considered appropriate in view of the employee's conduct of the previous year. Supervisors made every effort to address and redirect the behavior of the employee, but the behavior continued. No further action is deemed necessary as the employee has already been terminated, and no reinstatement or compensation is considered appropriate. This concludes the discussion. Thank you for listening.